on behalf of clients to see what was being said about their companies. Again, the users didn't control any of the ThoughtBuzz software and were limited to just using the uncopyrighted content that ThoughtBuzz made available through its crawler. And the Indian tax authorities argued that the ThoughtBuzz crawlers were, quote, stores of database information, and that users were making royalty payments for information concerning technical, industrial, or other type knowledge that was subject to withholding tax. And the Indian Authority for Advanced Rulings agreed in that case that was the case. And then recently in the Wipro case in 2011, we had a similar issue where Wipro was making outbound payments for access to a US database managed by a company called the Gartner Group. And this time the Karnataka High Court concluded that the accessing just the database without the user having any right to if the user was to access the database without the right, that would have been a copyright infringement. And on that basis, they concluded that the right to access the database constituted a transfer of the copyright rights embedded in the material that was being accessed, and therefore it gave rise to royalty income. The taxpayer was basically saying, no, there hasn't been a transfer of any copyright right because it's Wipro, the users couldn't exploit any of the copyright rights. It's no different than accessing a newspaper or a magazine. But the court disagreed with that view. And then actually, I just read a couple of days ago a most recent decision from November of this year from the Delhi High Court in a case called Infrasoft, where payments to a non-resident for software licenses was not in the nature of a royalty. So this is just a typical software license, where you go and buy a copy of a software like Microsoft Office, and it's called a license in form, but actually it's not really a license when you apply the rules. There hasn't been any copyright right that has been transferred. So under the tax rules, it's properly characterized as just a sale of a copyrighted article, and that was what the infrastructure court held, or the Delhi High Court held. So those are some of the cases. There are also some cases from other countries. I picked just Spain as one example. Amadeus, where the Spanish airline Iberia paid Amadeus to use its online booking system for passenger tickets, and the Spanish Supreme Court held that the right to use the computer program represented a right to use intellectual property, subject again to withholding tax, and should be characterized as royalties, not as a service. Even though again there was no transfer of any copyright rights underlying the Amadeus software. So those are some of the cases that have discussed the characterization issues. And I thought what I would do is end off with some of the discussions around the perennial issue of whether the server or a server may constitute a PE, and if so, under what circumstances. This issue continues to be one of the most hotly contested issues. I mean, some jurisdictions for companies are just sort of no-fly zones. They won't put any servers there because tax authorities have been pretty aggressive. But unfortunately, sometimes, as a business matter, it's just necessary to have servers located in the market country because of latency issues. In other words, trying to make sure that the data is delivered quickly to the customers, or data privacy regulations. In the European Union, for example, there are very strict controls on data privacy, and so you have a lot of requirements to have the servers located in the market country. You can't avoid it. So in that context, the question is whether a server constitutes a PE is whether the premises at which the server is located is at the disposal of the foreign enterprise. And some of the things that you're looking at are whether the foreign enterprise has control over the physical assets, the servers and the premises. Does the enterprise need personnel physically present at the server location? Is it okay for the foreign enterprise to manipulate the software and the data from outside the country? And what about monitoring the hardware and how it's doing from outside? Is that okay? Another question that often comes up is whether you could argue that the preparatory or auxiliary activities exception applies, because oftentimes these servers that are being located in a jurisdiction are there just for redundancy purposes, as a backup in case that the main server is having any issues. So those are some of the issues, and these issues are again under focus because of this whole BEPS and digital economy discussion that we're having. So let's look at briefly at the OECD commentary and what it says. And what it says is, the website by itself doesn't give rise to a PE because it doesn't constitute any tangible property. But the server on which the website is stored and through which it's accessed can result in a PE because the server itself requires a physical location, facilities. So there's a distinction drawn between the computer equipment that can result in a PE, or the facilities that houses the computer equipment, and the data and the software that's used or stored on that equipment, which under the OECD commentary at least generally doesn't constitute a PE. The OECD commentary also refers to an ISP arrangement and says that that doesn't typically result in a PE because the location of the server isn't at the disposal of the foreign enterprise, and this is important. Even if the taxpayer can determine that a website should be hosted on a particular server and at a particular location. And that issue comes up quite often in cloud computing because sometimes the contract between the provider and the customer will dictate that the customer's data has to be housed in a particular server at a particular location. And so you have to look at the terms of the contract to see what the deal is there. The key factors under the OECD commentary is that the foreign enterprise in this ISP, in a typical ISP arrangement, doesn't own or lease and operate the server. It's a conjunctive test. And so that's the general view, that the ISP arrangement doesn't give rise to a fixed place of business PE. It's also the view that the ISP arrangement doesn't give rise to a dependent agent PE because the website through which an enterprise carries on its business is not a person under the defined term of the treaty. And so you can't have concluding contracts through this non-person website. That's again what the commentary says. Now, India has entered into its positions on the OECD e-commerce commentary and says that it doesn't agree with some of the interpretations. First of all, India is of the view that a website may constitute a PE in certain circumstances that are undefined in the statement. And also, India says that, depending on the facts, an enterprise can be considered to have acquired a place of business by virtue of hosting its website at a particular server or at a particular location. So there are differences of opinion, and India is not the only country that takes that. There are other countries that take a similar type of position.